Good morning. Hi, my name is Scott Forcino again from Prime Real Estate, which is the teaching and training platform featuring some top trainers around the country. Our focus is teaching realtors how to better represent buyers and sellers, and teaching lenders and title companies and home inspectors how to support their realtor referral partners. It is now February, 18th or 19th, 2025. We're about 6 months past the settlement, and there is between the National Association of Realtors and the plaintiffs. And looming large in the background is the Department of Justice under a new administration that is still focused always on antitrust. It's a mistake to think that the new administration is forgetting about realtors and this lawsuit and the legislation that prevents consumer fraud and prejudice to sellers especially, and buyers as well. There is a big problem. The status quo that realtors are living within will end. So for those people like yourselves, the lenders, the title companies, the home inspectors, who are still relying on realtor referrals and between friendship and business relations and a great career, the bad news is what happened in the past was found to be illegal, collusive, violative of federal law, antitrust, price fixing, really, really bad words. Well, there was the settlement, which did not go far enough because the status quo allows for the realtor's continuation of getting paid, representing the buyer, paid by the seller. And that's not a problem in and of itself if it's done as is required. An offer of compensation is by the seller is something that can be discussed between their listing agent, their representation, their representative, their fiduciary, between the agent and the principal. And that's what should be done if a seller may want to pay for a buyer's agent representation. That could be and must be within the offer negotiation period. What is going on that is still violative of the antitrust legislation is what is called canvassing, where a buyer's agent might call 10 houses, 10 listing agents and say, do you offer compensation? 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 And that is pressure. That is canvassing. That's calling around. That means that each of those listing agents are told that if they offer compensation, the house will be shown. That's a form of steering. It's not racial. It's not gender-based. It's not the other form, very important form of discrimination or steering on those bases. But it's putting pressure on sellers. So it's very much like the former procedure and policy where sellers were required to offer compensation to a buyer's agent in order to place the property or submit the property to MLS. That was the policy. It's no longer the policy. The fact that there is still a question and answer regarding commission, it is felt by the government that is prejudicing the seller to pay without ever having the opportunity to even negotiate. That's why the rule is either by the letter or the spirit required that if a buyer's agent wants compensation so the buyer does not have to pay, they have to offer that as a term in negotiation, just like a new roof, just like a green couch, just like a new paint job, just like a new furnace. This is the buyer agent compensation request must be treated as a term of the negotiation, and all too often it's not. That's one reason why the plaintiffs in the lawsuit will file a petition for enforcement, and NAR does not have the money or any plausible deniability to say that this practice, which still violates the terms of the settlement, is defensible. When the petitioners file any violation proceeding or any petition for the finding of a violation, NAR will change its policy and offer no compensation to buyer's agents. It happened on March 13th and 14th, 2024, where overnight the policy that required agents to place their listings on MLS which required offering compensation to buyers agents. That happened overnight. This will happen overnight too. My message to those professionals, like the three, top referral partners for realtors, lenders, home inspectors, and title companies, is there must be a way for you entities to create stronger relations with buyer agents and provide them the level of enrichment and training and give the benefit of experience from those committed to making this real estate new policy environment a better place. We have those people. I can tell you that brokers, boards, associations either are ignorant of what's required or how they're running afoul of these new policy procedures in place, or they're unwilling to enlighten their members because business is still being done essentially the old way. Before, an offer of compensation was written in stone on your computer screen. Now it's not there, but it's still being broadcast. It's still being offered. It's still making the sellers obliged to pay as before. Further, there's a nuance where the government is thinking that sellers are being prejudiced by only receiving attention or offers from those buyers that sign buyer agency agreements. The government thinks that any obstacle such as that, which prevents eyeballs on properties, prejudices sellers. The government thinks that professionals speaking, arranging, corresponding is very, very close to colluding, and doesn't want any of that type of restrictive business arrangement to hurt sellers. Sellers are still, in a way, prevented from negotiating with buyers agents. That's why the workaround that they called it, which was fair and agreed upon, was that any offer of any request for compensation must be within a negotiation. Meaning, someone has to see the house, they have to like the house, they have to want to live in the house, they can afford the house, and oh, by the way, will you pay my agent? Because the initial requirement is buyer pays his agent. That's why there is a requirement of an agreement that makes buyers aware of what their agent will collect as a fee. The buyer has a chance to negotiate, look for a better deal, look for a better realtor, and then expect to pay the commission and not get any assistance from the seller. We don't have that now. We have a vestige, a remnant of the past, where buyers agents are required to sign, agree, but are covered by sellers because of the practices continued by realtors. That's the problem. And the Department of Justice tried to be included in the settlement last Thanksgiving, 2024, and offer the insight to say that any entity involved in these settlement between the two private entities, NAR and this class members in the Sitzer case, are not protected from the government investigation and enforcement. The judge in that case said, no. These are two parties. If the government has something to say it, but we're not going to include it in this court order. And it wasn't included in the order. So what did the government do? They said, listen, we're going to come out and make a statement and make the world aware that we are still very active in this investigation, and we are anticipating enforcement, and be prepared that no one is insulated from liability. So right now, realtors are not protected by anything. Referral partners are still dependent on realtors. There is no reason to think that if and when realtors are placed in the new policy environment, that they will succeed. There's no track record of agents being paid 100% of their sought after commission by buyers with no contribution from the sellers. If I'm wrong, I'm wrong anecdotally. There could be a situation that happened here. It could be 500 cases. It could be 5,000 cases. But there were 4.5 million transactions last year. So if I'm wrong by 5,000 or 10,000, $10,000 is a lot less than $4.5 million. Well, I'm telling you, we had 4.5 million transactions in 50 states, and a few possibly agents were paid solely, exclusively by their client. The commission structure that we knew is still existing, the status quo. And I'm telling you, the status quo is very, very, very strongly in question. I would go as far as to say when there is a petition forced by enforcement by the plaintiffs, where they're aware that these workarounds are not at all satisfactory, and when the government feels like ending this arrangement and requiring a complete decoupling, that NAR will immediately flip and give in just to survive, as they did before. Think about it. The sellers have been criticized, and this lawsuit has been criticized for getting just a few bucks. They had a commission for a $500,000 house. That was a $15,000, $12,000 commission, and the sellers got $29. And that was a joke, according to a lot of social media big mouths. Well, now, when NAR members are given the chance to fly right and comply with the terms, and they don't, if you were a seller and you saw an opportunity to get a little bit more than $29, and now we can revisit the case, we can void the settlement, and I get all my commission back, you have to realize these class members are happy that the realtors have not complied. That petition will seek the vacatur of the agreement, voiding of the settlement. We're back to square one with a judge has a proposed order on his or her desk, can sign it and enjoin and prevent any seller paying any buyer agent compensation in the future. So what I created, along with other esteemed professionals, gurus, trainers, practitioners, is a platform where lenders can offer and provide their referral partners training. The realtors get this at no cost. Buyers agents need to know how to navigate these new uncharted territory and waters. Listing agents need to have a firm command of how to represent their sellers within this new policy. The lenders, the title companies, the home inspectors need to know how to support their referral partners so they create a strong relationship and they survive. If all of your referral partners were no longer successful, what would anyone do? With professionals, we have a training platform anywhere from 6 to 12, 12 to 15 hours on video, on demand, for a negligible fee, something akin to a title insurance premium, 1 or 2 points on a mortgage. The fact is, if these agents who are not getting the training from their brokers, their associations, their boards, their attorneys, if they fail, they will not be in business. And whatever business referrals you receive, whatever percentage that amounts to in your monthly or yearly transactions, that will be gone too. I'm telling you that this enforcement is coming, and when it comes, there'll be no defense offered by NAR, and everyone is going to be thrust into the situation immediately, just like happened last March. So my name is Scott Forcino. My background is that as an associate broker. Been licensed for 27 years. I practiced law in the real estate field for over 23 years. I own a title company. I've been a bank attorney, New York City co-op and condo attorney, luxury market. I was admitted to federal court for almost 11 years. I've been reading this case since its inception, 2018, 2019. I've been watching it. I've been watching the appeals. And please remember this, just recently in 2025, the National Association of Realtors attempted to have the Supreme Court hear their case. They asked for what's called a writ of certiorari. Hey, Supreme Court, will you hear our case? In 90 days from the filing, the Supreme Court said no. They didn't even think enough of the case or NAR's assertions or allegations to give a reason. In almost all cases where there's merit or possible merit, the Supreme Court may say why they didn't think it was a novel issue. Parties needed to be protected. It was an essential community matter that needed to be addressed. The court just said no, with an N and an O. That's how important the government thinks realtors getting paid by sellers is. Not at all. So mine are words of admonition, warning, caution. And if the realtors themselves and those that work with lenders, title companies, and home inspectors are left to sink or swim in the very near future, NAR will have to comply or go bankrupt because they can't pay any of these fees or charges or damages um, or any interest that have accrued since 2023 Halloween. That's a lot of money. So be prepared. I'm getting you this as a colleague, a friend, an interested party, and we are here for the betterment of the industry, the members, the clients. We're all fiduciaries. We're here to serve the client. We are not here to deny what happened in court. We're not here to blame lawyers. We're here to serve the client, the consumer. We're supposed to be embodying the protections offered by the government. We're not here to look for ourselves and demand that we get paid like we did before, and realize that Who Moved My Cheese, the 2000 book, which described corporate alterations of business structures, the cheese not only moved, it's gone. Now is the time to get trained, prosper, survive, and really, really positive affect our clients and customers.